Okay, welcome. Ooh, this is a very lively mic. Hi all. It's great to see you here. I am Deborah Malamud, your loyal moderator for the day. So, discontent with the Trump presidency has put the question of impeachment at the center of public debate. But the purpose of this forum is to introduce you to the broader debate on impeachment. I will leave it to the speakers to figure out how specific they're going to be about current issues, right? But the big debate is a very important one, and I'll just cast it this way. Is removal of a president from office through the impeachment process itself a constitutional crisis? Is it something we should really be worried about? Or instead, is impeachment the Constitution's own mechanism for avoiding a constitutional crisis, with that constitutional crisis being the huge power of the presidency being in the wrong hands? So I'll set it up that way, and we'll see where we go. I'd like to introduce our speakers. We have Bob Bauer, who was White House counsel to President Obama and is now a professor from law practice here at NYU, co-runs our regulatory clinic in Washington, and that means that you have the opportunity to follow up with him in your days here. In addition to teaching, he writes regularly for The Atlantic, Lawfare, and Just Security on current political developments, including some recent and important pieces on impeachment. Professor Keith Whittington is the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton University, where he is a leading scholar of U.S. constitutional history. And in his recent writings, he too has been examining impeachment. One of the things they'll be exploring for you is where they fall in the range of opinions on this. I joked with them that we have some forums that are let's bring in the most extreme people and let them fight it out, others in which their views are nuanced, different in different ways, but not at the most extremes, and we'll see what we see. So what I would like to do is start with the basics, just a little bit of black letter here. Article 2, Section 4 provides that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes or misdemeanors. So what's the impeachment process itself? What role does the House play? What role does the Senate play? And what effect does impeachment have on the impeached person? So you can.
You want me to start?
Yeah.
Okay. So the process, as the Constitution lays it out, is very brief, and practice has filled in some of the details, but leaves a lot still to be determined by the institutions now. So the House, by majority vote, simple majority vote, can choose to impeach. The House has pursued that in various ways. Often they will launch their own investigation or inquiry in order to make that determination. Sometimes, though, they will lean heavily on outsiders who have already done most of the investigative work for them. At some point, they need to draft a set of articles of impeachment that lay out the specific charges that they want to pursue in the Senate. Usually the House does not vote on those separately, though. They simply make a single vote on whether or not to impeach. They then move to the Senate, which the Constitution specifies has a trial. It's up to the Senate to what exactly that trial looks like. And then the Senate ultimately will vote on each article of impeachment separately. Conviction of on any of those articles is enough to remove. Meanwhile, the impeached official remains in office until potentially the conviction at the end of the Senate trial.
Mm-hmm. Want to add anything?
I would add only each of these houses has the sole power, quote unquote, to do what they're constitutionally charged to do in relation to this process. The House has the sole power to impeach. The Senate has the sole power to convict. I raise this only because it is very unclear that the Senate is required to try a House impeachment. So you can imagine a case, and I don't think this is entirely inconceivable, that the House of Representatives would impeach a president as now, in the middle of or at the beginning of a presidential election cycle, and the Senate alleging all sorts of irregularities, the Senate aligned with the impeached president, alleging all sorts of irregularities, and also noting that the public is about to render a judgment in the next presidential election simply declines to take the case up. Now, that would require the majority leader of the Senate, if so inclined to do this, to maintain a body of 51 senators behind him or her in that effort. It's not something unilaterally I think that the majority leader can do, but a majority in the Senate could decline to take up, in my judgment, a House impeachment.
Do you agree with that, Keith?
I think that's right as well. And you can imagine the circumstances under which they would do it, both in terms of sort of the immediate circumstances where you say, well, an election is upcoming, so if it occurred relatively close to election season, you can imagine the Senate wanting to put it off and duck the issue. But you can also imagine an extraordinarily partisan House that, for example, is just constantly impeaching the president. Every week you pass new articles of impeachment. You can easily imagine the Senate at some point just saying, we're not going to continue playing this game where we're going to have a trial after every one of these articles of impeachment. We're just going to table some of these rather than actually hold a whole robust trial either way. So you can imagine sort of extreme circumstances where the Senate wouldn't do it, maybe even less extreme circumstances where the Senate wouldn't do it.
One of the things that's important to realize is that the House decision to impeach is a majority vote decision, but the Senate decision to convict is a 2/3 vote, right? So even a predictive judgment on the part of the Senate that there's no earthly way we will have the votes to convict, do you think that legitimately could lead the Senate to decide not to go forward? Or is that kind of predictive judgment, perhaps not constitutionally weighty enough in the shaping of the playing of that role?
I mean, I'd much prefer to see the Senate actually have a trial under those circumstances where you see the evidence presented and then figure out whether or not you have the votes. And so you can easily imagine going into the trial thinking that the votes aren't there to convict, and yet, and of course in these kind of high publicized circumstances, presumably not very much is going to happen during the trial that's going to be a surprise and would actually move people. But you can imagine it happening, and I think the Senate ought to at least have a trial. But again, I don't think they're constitutionally required to do it under those circumstances.
What came to mind when I heard Professor Malamuth's question was Majority Leader McConnell in the Senate saying he wouldn't bring certain bills to the floor if he knew the president would veto them. So you could imagine him making a similar argument, which is, since I know that the Democrats don't have the votes to convict, because I'm not going to lose enough members of my caucus to get us to 2/3, I'm not having a trial because it's a waste of energy, disruptive to the conduct of the nation's business, damaging to the president's presentation to foreign leaders, his ability to represent the United States in foreign affairs, so I'm not doing it. And that would not surprise me.
Mm-hmm.
You can also imagine restricting what counts as a trial to be something very minimal, right? And so again, it's up to the Senate as to what that looks like. So you can imagine a majority leader just saying, okay, fine, we'll have a trial, but it's 2 days.
And it's in committee with doors closed.
Well, conceivably you could do that, although I think it would be hard to sustain for a president. But for some judges recently, the Senate has relied on a committee to actually do the trial so that they don't take up the time on the floor. And so that's manipulable as well in ways that would try to shrink just how embarrassing it might be for the president to have a trial, how much time it would take, et cetera.
Okay, so let me actually, since you mentioned judges, the fact that we've got the same impeachment provision that applies both to federal judges, all civil officers, and to the president, raises this kind of question. I mean, you can see why we would need impeachment for federal judges, right? Federal judges have life tenure, and there's no other way to get rid of really, Judge Reinhart notwithstanding, their tenure really does end at death, but they do, if you're reading the newspapers, you'll know why I said that. But there's no other way to get rid of a really horrible judge, however you define horrible for purposes of the impeachment clause, right? But let's focus on presidential impeachments. We have elections. Since Roosevelt, we have term limits. So we have the election cycle as a way of getting rid of a bad president, and that really takes us to the theme of this forum. What's the state of debate right now over how extraordinary we should view impeachment as a remedy, right? Given that, we do have an election process that we can use to get rid of bad presidents. So just to give the room a sense of what the outer ends of this debate are and where you would place yourselves, I think it's worth posing that question.
So technically, I think the Constitution doesn't distinguish between judges or other civil officers of the United States or the president themselves. There's some argument that maybe The good behavior clause relative to judges alters things a little bit. I think most people would say it doesn't. There's basically the same standard applies across the board. But I think also most everyone recognizes there's a higher bar to trying to impeach and remove a president than there would be for a judge. Although I think that's likely potentially true for other high government officials as well. And so it's maybe a different thing to try to remove a district court judge as opposed to trying to remove a Supreme Court justice. For example, the stakes are just higher, even though there's not an election at play in the context of a Supreme Court justice. I think the election aspect of it does alter the calculus a little bit relative to the president. Certainly from the founders' perspective, there's a real concern, though, that even if the people are going to have an opportunity to reevaluate a president over time, you have to worry about what's going to happen in the 4 years in between. And so you can imagine circumstances in which the threat is so dire to the country that you can't wait till the next election. Certainly if it's not years away, maybe even it's not months away.
Right. Although that raises the question of whether those kinds of restraints should be read into the clause itself, or whether they are just prudential in the sense that we hope that the Congress, in making determinations, will trust the election cycle unless the threat is imminent. Bob,
I see the whole question of the standards for impeachment as falling across a very, very wide continuum. There are some who think a president can be impeached for any reason whatsoever, and they'll cite former president and then Minority Leader Gerald Ford, who said, it's whatever the House decides at any given moment it is. That is an impeachable offense. It's entirely at the discretion of the House. And then on the other side, there are the impeachment catastrophists, and Alan Dershowitz may be one of them, in fact is one of them, who says it has to be a serious crime, and literally a crime. First a crime, then you determine how serious it is, then you proceed to impeachment. Both of them, in my judgment, are wrong. It seems to me we also have to look at impeachment within the context of the evolving constitutional order. We have this odd arrangement where we have conferred upon the president, certainly throughout the late 19th through the 20th century to today, extraordinary and increasing amounts of power, much of it, by the way, for all practical purposes, unreviewable except by the voters periodically every 4 years. We also now have a dubious legal doctrine that the president can commit crimes and not be indicted for them, as long as he or she retains the office. And then on top of that, we have then the judgment that impeachment is so catastrophic, in Cass Sunstein's words, such a national nightmare, that we shouldn't impeach except in the most extraordinary circumstances. So to answer your question, Professor Malamud, my own view is that impeachment, we have to stop looking at impeachment as itself catastrophic, at the source of constitutional crisis. We have to look at it as a critical remedy against the harm that powerful presidents who have engaged in certain kinds of misconducts, the harm that they can do to the country. So I suppose I'd have to put myself on the hawkish side of the spectrum.
Mm-hmm. And where do you put yourself?
I'm probably on the hawkish side as well, in that I became interested actually in the idea of constitutional crisis in part because of my earlier interest in impeachments, and people do want to sort of raise the idea of impeachment being a catastrophe. It's a kind of crisis for the Constitution itself, very skeptical of the legitimacy of the mechanism. My interest in how impeachments have been used over the course of American history in part led me to want to emphasize impeachments are a really valuable tool. They're used for important purposes. In part, they've been used across American history to advance new constitutional understandings and practices that are terribly important. And so we don't want to take that tool off the table by characterizing it as a kind of crisis or catastrophe anytime we turn to it. We shouldn't be turning to it all the time. We presumably don't want to routinize it or normalize it, as Cato Institute's Gene Healy has suggested, for example. But we also shouldn't regard it as a crisis if it's in fact necessary.
So I want to come back to history in a second, because how many of you have taken constitutional law already? Okay, those of you who have taken constitutional will probably know that when you're dealing with big important separation of powers issues, terms within the Constitution that for one reason or another have proven to be non-justiciable, we look a lot to historical precedent in a sense to make constitutional law. So it's important to look at actual past cases of impeachment and see what the consensus is about them. But before I get there, I want to flag and then let our panelists comment on this. The phrase that seems to do the most work here is the concept of high crimes and misdemeanors, right? You could certainly see an argument that says that if it has to be a high crime and misdemeanor, and these are terms that come from criminal law, and high means heightened, that there's something to the idea that it has to be criminal and that it has to be kind of criminal plus. But there's also a tradition of interpreting this language in a way that takes it away from the criminal law context. There are questions about whether the acts have to have been acts that were committed while the president was in office, whether they have to be acts that go to the performance of the president in office rather than more generally to the president's moral character. So I'd like in your relative hawkishness, but not as hawkish as some, give us some sense of how you think this phrase ought to be defined, if not purely politically, if Gerald Ford was wrong about this, if it's not likely to be justiciable, so the Supreme Court is never going to answer it for us, although maybe you think there are some ways in which it could, I don't know, but what should be our working definition?
So I think it needs to be flexible in part, and precisely because it's hard to anticipate what issues are likely to come for you, what circumstances are likely to come for you, in which you need to use something like an impeachment power. So I think we always have to be a little cautious not to try to too tightly define what the scope of these powers are, and be excessively guided by what the history looks like, because we may find ourselves in unprecedented situations where we need to act. I think, though, our history certainly indicates that we're not limited to indictable crimes. Many of the impeachments that the House has pursued over the course of its history, and many of the times in which the Senate has convicted people on articles of impeachment, have not involved indictable crimes. And although frequently, of course, defendants will make this argument to both the House and the Senate that they shouldn't be impeached and shouldn't be convicted unless there are such crimes. The House and Senate have consistently rejected that, and I think for good reason, because they understand that this is often a tool that's necessary for primarily political reasons. They're worried about political abuses, and that sometimes require removal. I think the area that's somewhat more controversial beyond sort of abuse of government power are questions about whether or not the official has engaged in acts that are inconsistent with the dignity or nature of their office, which sometimes the House has impeached people making that kind of claim. That's often much trickier, I think, to identify as to what counts as behavior that's inconsistent with the dignity of the office, and certainly what is so severely inconsistent with the dignity of the office that actually would justify removal. That may be a little easier to maintain in the context of judges, where there's not an alternative mechanism for addressing them. A little tougher in the case of presidents, where ultimately the people can vote on that, but may be available even there.
I mean, of course, it's particularly difficult if some of the things that some people in the House and Senate think are below the dignity of the office are exactly the things that makes the president popular with a sector of the population, right? So
Yes. Well, and that's one of the reasons why there's I think there's an institutional responsibility that members have, looking to precedent, looking to how the impeachment clause has been construed and applied in the past, to take institutional responsibility, again, to take that institutional responsibility seriously and not simply read the public opinion polls, because that is a constitutional disaster. I mean, the Congress has an independent obligation here to weigh the fitness of the president against the standards expressed over time about impeachment. Just a couple of, I agree with Keith, first of all, that I think it is a flexible standard. It is not an uncontrolled, lawless standard. Philip Bobbitt at Columbia has made a very powerful case that Gerald Ford was dead wrong, that the Constitution looks to a reasoned process in which, for example, precedent over time is argued and very important to the disposition, to the outcome. And I think he's absolutely correct about that. It's not a purely political process in that particular sense. I do think, however, there's been some significant misunderstandings about some of the potential grounds for impeachment. It has been asserted, I think incorrectly, that so-called maladministration was ruled out by the founders, that a president who is incompetent, for example, is not impeachable. That confuses incompetence of a certain kind, of an extreme degree, with policy differences. I think there's a general agreement that presidents cannot be impeached and should not be impeached because the Congress happens to take up a different view on a policy matter, climate change, healthcare, whatever. And I think many believe that that was at the bottom, I'm not sure this is quite true, of the dispute between Congress and Andrew Johnson in the first impeachment experience.
We'll talk about that, right? Yeah.
Right. So I think that it is incorrect. If a president, for example, refused to nominate people to serve in the cabinet and simply strip the government of the mechanisms required for him or her to faithfully execute the laws of the United States, that is clearly an impeachable offense, even though the president would not be engaged in any illegal acts. But the president certainly would not be acting in a manner consistent with his or her constitutional responsibility. Last thing, a point I want to make about incompatibility with the dignity of the office. Keith and I were having this conversation earlier. We could have a conversation about a president, for example, who decides to kind of chuck it, expose all of his prejudices, and spout openly racist sentiments, conducts a Oval Office address, and decides to mount a framed photograph of the Confederate flag in the background. Do I think that kind of behavior in a president is impeachable on the grounds that it is incompatible with the status and dignity of the office? I do.
And then, of course, there's the question of whether saying, well, there's justice on both sides in,
Yeah, well, that
Yeah,
alone,
right, right.
so that
Oh,
alone.
I wasn't going to do that,
So
was
that
I?
kind of equivocate, you can argue it. I'm saying if you
Right.
take it to the next step, right, you take it to the next step, and there is just, rather than periodically retreating, then advancing along that front, trying to be sort of a little bit tricky about what it is that he's precisely saying, a president decides to just sort of go all in and expresses sentiments that are, clearly racist in character. I think that's impeachable.
Although I think that raises an important point that's worth noting, which is I think these are contestable political judgments as to where you are on that continuum, right? And so even if you think that the door is open to saying, well, in some extreme cases at least, a president ought to be impeachable and removable for those kinds of offenses, then it's a contested factual matter as to, okay, are we there yet, given particular actions? And in part, the high bar for actual removal in the Senate forces the issue a little bit of, you got to be able to persuade some of the president's own partisans that this is so extreme that it crosses those boundaries. You have to be able to persuade, I think, a wide swath of the American public that this is so extreme that justifies that behavior, which I think will effectively take a bunch of stuff off the table where we think, well, that's certainly disturbing, but it's not so extreme that the president's own allies, for example, are going to get off the bus at that point. And so it does sort of push us to thinking that some kind of actions that we think are inconsistent with dignity of the office, for example, are nonetheless bearable. Other actions are so gross and extreme that even the president's allies are going to say, okay, that's too far.
Right. I mean, it also, this commentary raises some questions about whether the impeachment process is subject to other constitutional doctrines that would limit it, right? I mean, if we have a court that strongly goes in the direction of worrying about basing judgments on, quote, speech alone. Do we say that while the political judgment that certain presidential forms of speech may be outside of the norms for the holding of public office, we might want to say that, but does an actual governmental action of removal from office run into First Amendment problems at that point? Does that become a way, perhaps, in which this question of what are high crimes and misdemeanors becomes justiciable?
Notably, as part of what we argued about with Andrew Johnson, right? One of the
Good, so let's this is actually a good point. So let's transition into putting the three historical examples on the table. I mean, you might think that any set of three is too small to be a set of political branch actions that you can really draw a reliable precedent from, but it's all we've got. So what we've got is Andrew Johnson during Reconstruction, we've got Richard Nixon, and we've got Bill Clinton. Johnson was impeached but not convicted and survived and stayed out his full term in office. Nixon was impeached and resigned before trial, and Clinton was impeached, tried, not convicted, and stayed in office. And these are our three presidential impeachment examples. And they present very different fact patterns as to what the high crime and misdemeanor was. So let's get them on the table now as we're talking about this.
Yeah, although I don't think judges are completely irrelevant either,
I know,
right?
okay,
And so
yeah,
we
right.
do have a more experience with judges, mostly low-level judicial officials, but we have an impeachment of a associate justice of the Supreme Court, for example.
do.
And those, I think, do sort of inform a little bit what we think the tool is useful for and the scope, although I think, like I said, I think presidents raise these issues in slightly different ways. But it's worth noting with Andrew Johnson in particular that he was impeached for several things. One of the things he was impeached for was specifically speeches he was giving. So he gave public speeches in which he denounced the radical Republicans in Congress as being just as bad as the leaders of the Confederacy. They didn't take that well, thought it was ultimately an impeachable offense to make those kinds of claims about them. They thought it undermined the dignity of Congress itself and undermined the ability to maintain peace at the end of the war, to have a president making those kinds of assertions about Congress. And this also comes in a time period in which presidents did not say that kind of stuff about members of Congress or Congress as an institution. And Johnson broke all kinds of norms about what presidential speech making and rhetoric look like at a time in a way that people thought was dangerous in a Republican form of government. And so as a consequence, one of his articles of impeachment focused precisely on that. Johnson, in parts, wanted to argue, I have free speech just like everybody else, I can say whatever I want. And part of the response was to say, yeah, but you also have certain responsibilities as president, and you can't say whatever you want and have no accountability for them. There are some things that are unacceptable for presidents to do that might be fine if a private citizen did it. And I think that's probably the standard we'd want to use now as well.
What comes to mind when I think about this whole question of can a public elected official lose office because of free speech, I'm reminded now, speaking of, and again, I'm going to move to the Congress here just for illustrative purposes, Joe McCarthy in the Senate in 1954. He was censured and his political career destroyed because the Senate applied discipline against the manner in which he spoke. Calumny visited upon the institution, condemnations without any basis of facts, virulent condemnations of his colleagues for actions they had not committed. And of course, many of his supporters said he was speaking his mind and he was speaking to a constituency which for a while at least was very receptive to what he had to say. And he was drummed out of the institution. Now you take it to the presidency where we speak of the president in these very hallowed terms. The president speaks for the nation. The president is supposed to embody what is best in the nation. The president is inaugurated and is supposed to bring the nation together. It seems inconceivable that at the same time we say, and can behave any way he or she wants, no problem. Racism, public inebriation, grotesquely sexist conduct, no problem, even though arguably the president represents the country both at home in certain respects and certainly overseas, in a manner that has a really significant effect on the conduct of our foreign policy. In Andrew Johnson's case, I've always thought, and I'm not an expert and a scholar of the Johnson impeachment process, so this is at somewhat of a distance, that the question of impeachment in Johnson's case has been, at least in lore, very much oversimplified. And there was a strong reason for Congress to believe that Johnson was acting well outside his authorities as president and subverting Reconstruction policy in a variety of ways, some of which were actually quite underhanded. Mm-hmm. It ended up becoming the view of the Congress, and I think this was fateful, that they had to find a specific statutory offense that he had committed. So they decided to brush past the demagoguery and brush past the larger constitutional issues raised by his conduct and focus on his firing of his ability, his constitutional authority to fire his Secretary of War. And that's unfortunate because I think that the outcome was widely celebrated for many years to come, including famously by John Kennedy in his book Profiles of Courage, the profile of courage being the member who stood up, I think, in the opposition party and voted not to convict. And I think it had an unfortunate effect in shaping our view of the impeachment process.
So that's a debate that's not only about speech as a basis for impeachment, right, but is also, and here one has to, find the right spot. It's certainly a debate about policy. There was nothing more important, and I think in many ways remains nothing more important in American history than the question of what Reconstruction was going to look like. Right? And you had the major question of who was going to control the process. Was it going to be a presidentially controlled process or a congressionally controlled process? And when Professor Bauer is saying when they looked for a law violation that they could base it on, they couldn't base it on any of the moves that he was making for presidential control. It raises the specter, and this is a little bit contemporary, of a president who just keeps pushing to the outer edges of presidential power, consistently, not necessarily violating any existing statute, not necessarily violating the Constitution, but nonetheless pushing in that direction so consistently that as precedent for the scope of presidential power is made through action, allowing that person to continue to act in that manner will make, in that sense, bad law for the future. Is that reason enough? I mean, do you think that in Johnson's case, if the battle really had been about Reconstruction itself, that would have been enough?
So, I mean, part of what's striking about the Johnson case is that both Congress and the president were aggressively pushing their powers to the limit and were innovating about what their powers looked like. So Congress passed a statute that restricted the ability of the president to fire his cabinet members, for example, which this court subsequently looked back on and said, well, that was clearly an unconstitutional thing to do. So Congress was doing all kinds of things to try to rein in the president that were pushing hard at what the boundaries of their own power was. Johnson was doing the same thing in response because the stakes were very high in Reconstruction policy making. And in part, precisely because we can see the stakes are very high in an instance like that, I'm a little reluctant to say there's never a circumstance in which policy disagreements might not lead to the possibility of impeachment as well. We don't want to, I think, use impeachment as a normal tool for settling policy disagreements, and the fact that it's so hard to convict in the Senate almost certainly means you wouldn't use normal policy disagreements as a tool for doing that. But on the other hand, I'm a little reluctant to say there aren't extreme cases where something that we might characterize as policy is nonetheless so far out of bounds of the large consensus of American politics more generally, and we think it's so potentially dangerous that we wouldn't want to say, okay, we have to actually impeach and remove on the basis of that. I don't know quite what that looks like in practice, right? It's a little hard to imagine, but on the other hand, if President Trump decided tomorrow, I'm pulling out of NATO and I'm entering into a set of executive agreements with Russia, who's going to be our best friend going forward, maybe you get there, right? Where you think the policy disagreements are now so severe, so extreme, the consequences are so grave that there's actually a consensus in Congress on both sides of the aisle that you can't tolerate that, and you got to take action.
So I agree. I agree that there are what you call extreme cases. I'm not quite sure how to characterize what I would think the word extreme means. In other words, how extreme and by what standards extreme. What I think about when we talk about when Professor Malamud refers to pushing the constitutional boundaries, I think about another set of choices that were made in the case of the Nixon impeachment. Now, Nixon was impeached for all sorts of really outstanding reasons on a very full, well-developed factual record. And I think we should note, I can't help but note one of the more notable moments was testimony from one of his lawyers. I'll leave it there on the table. But it's interesting that Congress decided that many of Nixon's more imperial presidential moves wouldn't justify it. So they went to the whole series of actions that he took to illegally handicap his political opposition, including his re-election opposition in 1972, and that was perfectly appropriate, and the cover-ups, and the lies told to the American public about it. What they left, if you will, on the cutting room floor was the president's decision to impound funds that had been authorized by Congress that he didn't want to spend as president. His decision, for example, to expand and lie to the public about a war that went from Vietnam to Cambodia, essentially undercover. And they thought about it and decided not to bring those claims. And so we're back again to this instinct on the part of the Congress, I think largely under the pressure of the view that we have to have something really tangible and criminal, which in Nixon's case was more than tangible and really
more than criminal.
Yeah,
right.
really criminal. But we have to have that because the rest of it just brings us too close to these conflicts between Congress and the executive of a constitutional nature. I think that can be taken too far. I think that argument can be taken to the extreme, and I share Keith's view. There are times when Congress simply has to be prepared to articulate the case that the president has pushed, as you say, in an unconstitutional direction in a way that needs to be both stopped so he's not encouraged to do it again, and also so that no untoward precedent for future presidencies is established.
Although I think in this case we also want, I would think that we want to be cautious in reading back into Nixon and the Watergate episode the view that because Congress did not choose to include some of those things in the articles of impeachment, therefore there can't be impeachable, those cannot be regarded as impeachable offenses.
Oh, I don't disagree.
No, I think
absolutely
that's
agree
right.
with that.
And partially, certainly, Congress was reluctant, in part because there were people in Congress who thought those are not impeachable offenses, and we can't bring those forward because it's inappropriate and they fall outside the bounds. Others, I think, are more willing to. I think the real thing that holds Congress back in that case is precisely the fact that there, in fact, was no widespread agreement that impoundments were unconstitutional, for example. There was no widespread agreement that secret bombings by the president unauthorized by Congress are unconstitutional. And so part of the challenge, I think, for Congress during the Watergate period is that there was no widespread consensus about what presidential powers ought to look like. And as a consequence, while lots of people were uncomfortable with what Nixon was doing, they weren't necessarily comfortable with saying, and therefore Nixon's clearly out of bounds and we need to draw the boundaries in a much clearer way, in ways that are going to restrict it. And without that kind of consensus, then you pull back and say, okay, well, let's focus on the things we agree about, rather than try to have an impeachment on the stuff we don't agree about.
This may be one area where you and I have a disagreement of whatever significance I'd be prepared to attribute to it. And that is, I worry about the word consensus.
Yeah.
I really worry about that. It starts to shade us also in the direction of Congress looking anxiously at the public opinion polls. Public opinion polling is in any event variable. It can be shifted and read, and frankly, as we know from the 2016 elections, they're not always that terribly reliable. And so...
Well, can't you say the same thing about elections?
Yeah, well, there's that.
Yeah.
Fair enough. But it seems to me that if a majority in the Congress, and then ultimately if they think they can get to 2/3 with a significant enough of defections with the party most aligned with the president, concludes that there are serious constitutional stakes that simply have to be defended, then I'm not worried that they start out with a country that's somewhat divided on the question and an opposition party that resolutely wants to defend the president. I mean, these are institutional obligations. Now, granted, they have to make these decisions in good faith. They have to have a process that's credible. They have to build a record. They have to articulate the standard and argue the application of the standard to the record. All of that, I think, is essential, no question about it. But I don't worry all that much about consensus, especially in the early going when the case has to be made.
No, I'm totally with you on that. So my first sort of examination of impeachments was looking at things like the Johnson impeachment, the Nixon episode, but also the impeachment of Samuel Chase. Notably, in the impeachment of Samuel Chase, Justice of the Supreme Court historically regarded as a failure precisely because the Jeffersonians couldn't convict and remove. And my argument on Chase is we ought to regard the impeachment itself as quite successful in accomplishing what the Jeffersonians were most concerned about accomplishing, which is to tell Supreme Court justices quit behaving in such a partisan manner from the bench, and there's a set of activities that Chase was engaged in and that the Federalists wanted to defend, that the Jeffersonians say, going forward, this is unacceptable. And justice should not behave in that fashion going forward. And on that, they were quite successful, right? And so that was not a consensus. The Federalists were more than happy to stand up and say, no, these behaviors are perfectly fine and we approve of them. And the Jeffersonians, on a mostly partisan basis, were very successful in establishing a new political consensus moving forward. That's not what we're going to do moving forward. But it starts off as a partisan argument that was not a bipartisan or certainly not a consensus argument, but one that built support over time. And I think that's an important thing you can do with impeachment.
So, I mean, does that suggest that impeachment, rather than being something extraordinary and rare, really are just a heightened form, really just a heightened form of congressional oversight? That predictions about whether the Senate will actually convict really have no place? That it becomes a privileged place for Congress at a high level to express itself on very highfalutin and usually non-justiciable questions of separation of powers. It's a place for norms to be contested and reworked in a way in which careful reading of the historical record will suggest shifts in norms having taken place as a result of the process. Right? That's very, very far away from some image of impeachment as about we wait for the special prosecutor's report and see whether anything criminal happened. Very, very different texture to it in that case. And one that also suggests perhaps that we need more of them because we need more of these kinds of precedents to develop. Otherwise, particular instances with their particular peculiarities will take on too strong a set of meanings. I don't know what your response would be to that.
Yeah, absolutely. So let me then plug my book, Constitutional Construction, which came out just after the
There.
Clinton impeachment.
Right.
And that, and in there I wanted to make that argument that precisely this, that Congress uses impeachment sometimes as a vehicle for trying to reestablish norms, try to reestablish what a set of practices ought to look like. I think the caution on that front is you have to be able to build the political argument that that's what you're trying to accomplish, and you have to be capable of building political momentum behind those views. Otherwise, it's a failure not because you didn't remove the person that you're targeting, but because you're unsuccessful at establishing the new norms that you were trying to establish. And I think you also have to worry a little bit that the mechanism can get watered down, right? So if you're impeaching people all the time, then eventually people stop paying attention. It becomes a much less effective tool for accomplishing this purpose. And so it can be very powerful, but it can only be very powerful if you use it in the right way, and presumably if you use it relatively rarely.
Yeah, I'd hesitate to characterize it as an extension of the oversight power, because then that would really suggest to people that it was becoming routinized, and then the dividing line between what constitutes strong oversight and what is a platform for impeachment might get lost, and that could be very dangerous. But I do agree, and this goes back to the hypothetical about the president who spouts openly racist sentiments or mounts the framed Confederate flag behind him during an Oval Office address, that there are times when impeachment is a necessary step that has to be taken to establish certain norms, which includes setting boundaries around speech that a president can engage in. I mean, degrading speech toward minorities, toward women, unacceptable in a president, incompatible with the status of the office, and if it becomes necessary to use the impeachment process to set that precedent, and I would assume, Keith, that wouldn't mean that you're doing it all the time, hopefully. Hopefully we're not repetitively and routinely electing presidents with those kinds of mindsets, in which case we have to look at other problems that we've got. I don't have a concern about that.
Although you could worry there's a partisan basis for the norms, for example, and so one party consistently thinks the other party is violating really important fundamental norms, whereas the other party just never has accepted those norms, and so won't take that view. And if you used impeachments as part of the vehicles by which you're having those fights, then you can imagine just constantly trying to impeach the other side, precisely in order to make this point that you think is terribly important to make, that we think these people are behaving in an unconstitutionally inappropriate way. But it's unresolved, and so you keep winding up having to fight precisely because you can't win enough political support to dominate. I mean, part of why the Jeffersonians are so successful in the long term is because the Federalists go away. And so while they weren't capable of removing Justice Chase, the justices in general sort of thought, okay, well, that was bad. We should never do that again. And so we should change our behavior. And the Federalists who were going to defend him all lost elections and disappeared, and the Jeffersonians became the dominant vision of what American politics ought to look like. And if that's what you're doing, then you can make it work. But if instead you're sort of stuck in a persistent Democratic Whig scenario, for example, where neither party can completely eliminate the other, if the Whigs were just constantly impeaching Democratic presidents because they were behaving very badly from a Whig perspective, then you could imagine them impeaching all the time, and it just doesn't mean very much.
Well, that's why the issue.
Yeah.
I'm sorry.
No, go ahead.
That's why the issue that I rested my case on as in relation to free speech was race. Right. Because I think that you can make the argument that you don't have, this is not a contested norm.
Well, you know where I'm going to go now, right?
Okay.
Which is from race to gender, right?
Gender, correct.
So we've talked about Johnson, and there, you've gotten a sense that among historians of constitutional practice, there are some debates about what lessons one ought to take away from Andrew Johnson's both impeachment and conviction failure, right? We've talked about Nixon, which I think is being presented as a consensus case in which you need an impeachment process for this. It went the way it was supposed to do. And then there's Bill Clinton, where shifts in time and refocusing on behavioral norms might create different judgments from those originally rendered. So I suppose I have to go there, right? Which is that in light of Me Too, in light of the increased focus on sexual predation, sexual harassment by those in power, does the Clinton case look different from the way it looked? Because I think it looked to a lot of people like, obstruction of justice is a crime, but if the underlying offense is a stupid one, maybe we're not going to worry about it too much. I think we might tell those stories a bit differently now from the way in which they were told then. So, floor is open.
You want to start with that one?
Yeah.
There's a documentary that some of you may be seeing called The Clinton Affair, which I think is on Showtime or Netflix or whatever. And there's the last quarter of it is really quite stunning. Some of the arguments that defenders of President Clinton were willing to make publicly are absolutely shocking. Talk show hosts who said things that would today mean that the following day they wouldn't be on the show any longer, they would have been fired. I mean, just astonishing. So you have a chance to see it. You have to go a long way to get there. It's interesting along the way, the entire experience. But when you get to the end and you start thinking about what people said in his defense on the question of his behavior toward Monica Lewinsky and other women, it's really quite shocking. It would be completely out of bounds in this day and age, completely out of bounds. I mean, maybe not everywhere, but it certainly is not something that people in the public eye, for the most part, would be allowed to, or it would be acceptable for them to say. Now, let me just very briefly say, in the Clinton case, I was involved in the impeachment. I was outside counsel to the Democratic minority in the Senate. And my own view at the time was actually a purely institutional one, setting aside the various claims about Nixon's conduct, and there weren't many people who thought it was without blemish. I mean, there were real problems with Clinton's conduct. The problem, and I think it's easy to make this mistake, was the way that the impeachment process itself was structured, the way the impeachable offenses came about, which was, from the Republican point of view, lying and obstruction of justice, in which the president essentially fell into a trap, remarkably, that the Republicans set for him, or some Republicans who were opposed to him, some conservatives who didn't like set for him. I don't mean the Republicans in the Congress. And then the wholesale reliance on the record that was established by the independent counsel, Ken Starr. In that impeachment, the House did not call a single witness. It did not develop any independent investigative record whatsoever. It just shipped the entire Starr report effectively to the United States Senate. The Senate, knowing full well that there were not 2/3 of votes to acquit, kind of went through the motions and conducted 3 depositions, entirely 3 depositions in the case. And for the rest of it, it was just argument on the floor of the Senate. It seemed to me this was so clearly an abrogation of the kind of seriousness with which an impeachment case should be assembled. I thought that on that ground alone, Clinton should not lose his office. Now, having said that, there were other factors, not the least of which was that after all the argument had been made, and again, I'm very reluctant to say how much weight should be given to public opinion, but it weighed very heavily on members, that by the time the trial occurred, the close to 2/3 of the American public were on record across all public opinion measures against removal from office. And that made the situation, together with the other institutional features that I thought were aberrant, impossible.
My objection to the Clinton impeachment at the time was the Republicans were doing a very bad job of trying to make the argument about why you ought to impeach under these circumstances and why impeachment removal would be necessary in these circumstances. I think they fell into the trap of thinking about impeachment as only justifiable in these very narrow set of circumstances, which are primarily criminal ones. And so they wanted to jump on the idea that there was obstruction of justice and perjury, and therefore Clinton had walked through a tripwire that now triggered impeachment, and you could just do it as a mechanical process, rather than understanding it as fundamentally a political process in which you had to build the case in public about why these particular acts are so egregious and so abusive, that this is the appropriate step you ought to take next. And they weren't willing to do that. They weren't willing to do it either, I think, in terms of explaining why obstruction of justice in these contexts is actually so inconsistent with the office that requires action, nor were they willing to do it in terms of the kind of norms about how you deal with interns and the sexual aspects of it now, which I think the norms have shifted to some degree. But Republicans also weren't very willing to sort of make the argument in public that would begin to shift those norms or play off those norms in a way that would say, here's what's at stake, and here's why we need to actually have this fight. They let Ken Starr do all the work, and that's not enough.
Yeah, so there's kind of an irony, it seems, just as an observation about that, which is that, you might think that Congress thinks that in the public eye it is acting most legitimately when it treats impeachment as kind of a criminal matter, and then defers to the experts in criminal prosecution and says, no, 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 we're not laying a hand on this. We're taking an existing criminal, clean hands kind of investigation record and basing it purely on that. And yet your charges both are that doing that approaches impeachment without the political sensitivity that gives it, as a constitutional process in the political branches, legitimacy. It's kind of like politics becomes a double-edged sword here.
That's absolutely right.
Yeah.
And I think we see this as a real danger. I don't think, by the way, that Mueller will fall for this in the way that Ken Starr did, in my judgment. If you're really interested in Ken Starr's defense, he recently published a defense in a book called Contempt, which is a memoir of how he handled the Clinton impeachment process, and it's revealing in a number of ways. But the notion that everything stops, the argument begins and it ends on any question of impeachable offenses by the current president with the publication of the Mueller report, and there's a whole set of issues about what we'll learn about the Mueller report to begin with, I think is a grave mistake. I don't see any evidence whatsoever that that's how, to the extent that one has evidence, I don't see that there is much evidence that that's how, in any event, the special counsel understands his role. But I think that's a critical and important question.
Okay.
I think that's also where the history of judicial impeachments can be misleading for Congress, that most of the impeachments that they've done over time, especially in the 20th century, have focused on trial court judges and often focused on criminal offenses. And as a consequence, I think it's easy for Congress to sort of be misled to say, well, this is what we did all the time with all these judges, we can just do the same thing in the context of a president. And I think there's a misunderstanding about what the overall history of the impeachment power looks like, what it's there for, and certainly what it means to try to translate that power into going after a president.
Okay, so I had a really cool last question, but I am not going to answer it because ask it, because what that little beep meant is that it's now your time to ask questions. We have microphones that will make the rounds to you, so raise your hand, a microphone will find you, and the floor will be yours. Okay.
Hi, thank you for being here today. My question was about when we look at the fact that there are differing interpretations of what high crimes and misdemeanors mean, what the scope of those impeachable offenses are, with Dershowitz on one side, and then you both seem to be somewhat in the middle. Are there any institutional mechanisms that actually prevent? Let's say, for example, that both the Senate and the House of Representatives had a Democratic majority. We have this sort of vague understanding that Congress is supposed to abide by the Constitution, and we have the Supreme Court to intervene at times when it thinks that it's gone too far. But if for impeachable, to my understanding, impeachments aren't reviewable by the Supreme Court. Is that correct? And if not, what are the institutional mechanisms that stop, let's say, two houses with opposing parties, majorities, really just impeaching whenever they want? What's as a practical reality?
The practical reality is probably purely political, that, if the Republicans at some point started to panic around the Clinton impeachment, especially in the Senate, because it became increasingly clear it meant less to House members who were a little more hardcore on this subject, but the senators became very agitated, Republican senators did, about the absence of any meaningful public support for impeachment and some resentment that the impeachment process had gotten in the way of the government of the country. That seems to me to be largely the check. We haven't talked about the justiciability of these matters. I would, who knows what the Supreme Court would do? You could imagine a case, I suppose, where an impeachment was on grounds so frivolous, so poorly articulated. And by the way, we spoke earlier about process. The House moves to impeach rapidly on frivolous grounds. It's done in 2 days. It sends it to the Senate. And the Senate, believing that the public's understanding of how long a trial might take is based on Law and Order reruns, so it's over in an hour and a half, then I think that's possible that the Supreme Court of the United States would step in because, I cite to you, extreme cases always make a difference, Bush versus Gore, where the court stepped in a presidential election, stopped to recount, decided the outcome, and said, this time only, nothing we just did here counts as precedent.
So I'm skeptical that the court steps in even on that, although I think it does depend on the circumstance. You can imagine circumstances where the court might step in. I would want to push back a little bit, I think, against the thrust of the question. I mean, part of my interest in constitutional politics generally is to emphasize that these are constitutionally responsible actors in their own right. And so the same question you ask, well, what stops them from making really bad constitutional decisions that we think are inappropriate? It's the same answer as the court, right? The 5 justices on the court can just as easily make the bad decisions, and where do you go from there, right? And so just because Congress is the last stop in making the argument doesn't mean that therefore there's nothing constitutionally appropriate or relevant about what they're doing. They are the constitutionally responsible actors to make important constitutional decisions. They have to make those decisions and justify them in public, and they can be held to account and criticized if they're doing it wrong. But we should also be sort of comfortable with the idea that sometimes presidents are the last actor to act on constitutional issues, sometimes Congress is, as well as sometimes the justices are.
Well, I think I would allude, I'm not going to speak very much, but I would allude back to Bush versus Gore and say, you know, part of what writers like Professors Bauer and Whittington are doing is writing to the Supreme Court as an audience. The Supreme Court sure didn't seem comfortable with the idea that the political branches could handle the situation in Bush versus Gore. They tend to believe that it's a constitutional crisis, and that means that they have to solve it. They, in a sense, are the people who should be out in the audience listening to people saying that even though it's murky, even though it's a gray area, there's actually constitutional validity to letting the political branches fight this out for themselves. They're really the audience for that argument, because otherwise that's the way it will happen, right? Okay, next question. We have somebody over here.
Thank you both. If it's on, I can speak loudly. Thanks for being here.
It's being recorded, so if you could use the mic, it would be helpful.
Okay. So could you speak a bit about developing the record upon which impeachment proceedings take place? You mentioned a bit about how the House basically sent on the Starr report in whole to the Senate. And in this case in particular, the one with potential facts in potential impeachment, there's a lot in an area of alternative facts that could be disputed, that has been disputed in the public sphere and might not be widely accepted. Could you talk a bit about how that might be handled in the future, whether it's in a Trump presidency or a future presidency?
So it's really up to the House about making a political and maybe in some sense a legal assessment about how much work they need to do in order to pass it on. And I think part of what they want to be thinking about in deciding what kind of record to construct before they have to move forward is, one, what can you defend in front of the Senate? So you need to be confident enough that you have the evidence that when the trial occurs in the Senate, that you're capable of presenting the prosecution to say that impeachment is justified. And secondly, I think you want to worry about what the public case is. How much have you persuaded the general public that this is an appropriate thing to do? And there may be circumstances where you don't need to collect a lot of additional evidence. You don't need to have a lot of additional public hearings before you feel like you've done what you need to do on both those fronts. But there's lots of other circumstances where you can easily imagine, the House itself needs to have big public hearings precisely in order to sort of build that political support before we move it over to the Senate and have a public trial. But to some degree, I think that too, as to how much work you need to do, is a political judgment that has to occur depending on the particular situations and how it's developed.
Yes, I agree, and I think in a polarized politics, I think it's particularly incumbent on the majority in the House of Representatives today, or any future majority House under similar political conditions, to display a high degree of sobriety. And that means moving not slowly, that is to say with undue slowness that reflects anxiety about impeachment as a nightmare, but in a methodical fashion, building the case about the appropriate standards, trying to create a record amid all the political noise and obviously the shrieks of complaint from the opposition. Does that break through? Well, obviously in a cable TV, internet, social media dominated political dialogue, it's a very, very hard task. But I think that just heightens the responsibility to try to do it that way. I've heard some criticism, if we're going to speak about contemporary conditions. We don't have an impeachment inquiry underway, but it's clear from comments from senior House leaders that they are preparing to at least have the elements in place for an impeachment inquiry, that it was a mistake of the House Oversight Committee to call Michael Cohen, the president's longtime lawyer, as a first witness. That it just meant that from the very beginning, and if you saw any part of the hearing today, that's certainly the theme the Republicans were sounding, that from the very beginning it's meant to, embarrass and harass. He's out of the country, he's at a summit, his lawyer had put together a pretty raw indictment of him as an individual. There are arguments that go the other way, but these are the procedural choices that become extremely important in establishing the credibility of an impeachment process.
Yes.
Hi. I was going to ask about the testimony going on today too. I saw some commentary about some cynicism, showing some cynicism that whatever Cohen says, it's not going to change anyone's mind, whether whichever side of the aisle they're going to be on. So. And since you've spoken pretty broadly about impeachment in general, I'm still thinking about the practicality of it today when we're in this more polarized environment. I mean, it's not like I could say the time when Johnson was impeached wasn't polarizing, I assume too. So I'd be curious to hear any more thoughts about like the current climate right now.
Yeah, I mean, I think it's tough, right? I mean, trying to persuade people on the other side of the aisle that this is an appropriate thing to do is a difficult challenge, especially when you're confronting presidents, right? It's a different kind of challenge than if you're talking about a district court judge. And so the stakes are higher. People feel more commitment to a president, and so there's more of an instinct for partisans to want to rally behind a president, and that's all true. And the Johnson impeachment is also historically extraordinarily unusual because the Republicans had enough votes all by themselves to impeach Johnson. They didn't need the Democrats on that front, and the Democrats were all against it. And so the debate was all an internal Republican debate. But it's very rare we have those circumstances where you have enough seats in the Senate that you don't need to worry about the other party. All you got to do is hold your own coalition together. I think part of the challenge with Trump is precisely that one, though. What piece of information would it take to start carving away Republican support away from President Trump? And so far we don't seem to have found it. Right? So it's and certainly there are some kinds of things that get laid on the table where it strikes me as very implausible that Republicans are going to be motivated by campaign finance violations to think, okay, well that's good enough reason to impeach or remove Trump. So it's a challenge to try to think about, okay, what's the kind of evidence, what's the kind of argument that you can put in front of somebody that starts peeling away support of Republican voters, but also support of Republican senators.
I mean, this goes in the direction of that last question that I wanted to ask, which is, it's really difficult to impeach if the president's own party continues to support the president. At the point at which, in a sense, I mean, we don't have this mechanism, but on a party level, if you think of parliamentary systems, right? At the point at which a president would lose a no confidence vote from his or her own party, right? That might be the point at which you could convict, but it might also be the point at which the damage that presidency is causing can be cured through other non-impeachment mechanisms, right? At the point at which the president can't pass damaging legislation, at the point at which the president is clearly, if it, going to be subject to a primary challenge in his own party primary, is the only point at which we could actually achieve impeachment the point at which we really no longer need it?
What that question brings to mind is, should we feel better because Republicans may very well vote against the president on the question of whether or not he properly declared a national emergency. Of course, if the Congress does in fact enact by joint resolution a disapproval, the president can veto it. So there also,
so I have that 2/3 threshold of what it means to lose your party's support again, right?
Exactly. And then there's the question of, is this going to be a game of constitutional whack-a-mole? One of the great advantages of impeachment is you don't have to worry about it anymore because the president's gone. In the world that you described, the majority party and the minority party are all chasing around after the president, and after all, they can only address what they know. And that's, I think, the reason why I don't know that some more responsible behavior of a president's party addresses decisively whether or not you need to move to impeachment.
I have a piece about to come out in Lawfare where I'm concerned exactly with that. I think partially when you're making arguments on behalf of impeachment, you have to be thinking about what is this going to remedy and why is this the right remedy as opposed to something else you might be able to do. So part of how Andrew Johnson wound up persuading a handful of Republican senators to not convict him was to persuade them that he was safe, that you could leave him in power for the next few months that he had remaining in his term, and he wasn't going to continue to fight Reconstruction in the same way as he had before. And in fact, he stopped, right? And so a handful of Republicans became convinced that we had done what we needed to do in order to successfully neuter this president under these circumstances. And likewise, you might think similar kinds of arguments can play out in the Trump context. And so if Trump fires James Comey, one response is, well, you got to impeach and remove him, and the other response is say, okay, is there another vehicle by which we can get a investigation moving forward such that we can work around the obstacle that Trump has created in that context? And when you're convinced that that's not possible to work around it anymore, then impeachment becomes more and more the likely remedy that you have to go to.
One other concern that I think the polarized politics of the time has, I think it's implicit in what we've already said, is that Republican, or let's just, if we wanted to flip it in some future world in which the shoe is on the other foot, we could do that. But right now, speaking of contemporary circumstances, Republicans' beliefs about the conduct of Donald Trump and whether or not that conduct is incompatible with the status of the office is probably fairly keen. He's not popular on Capitol Hill. His own party doesn't like him at all. But they'll take what he offers them. He's a vehicle for the achievement of policy goals, some of which they can push because he doesn't care particularly and he won't stop them, and others which he is prepared to help them to achieve. And that is a very alarming state of affairs if you look at impeachment as potentially a presidential norm establishment and preserving function. If the end of the day is all of that gets traded away because of the advantages of a particular presidency to achievement of a particular policy program, it really does require us to think hard about, the ways in which contemporary politics undermine at least one of the functions of the impeachment process.
I think that's totally true, although I think it's also true that Republican senators and representatives, for that matter, are worried about their own constituents as well. So to the extent that Republican voters continue to be highly supportive of President Trump, it makes it very hard for Republican senators to think they ought to break from him. And they have a separate calculation about what kind of policies we're getting from them. You can imagine that it gets to the Senate for an impeachment trial. A lot of senators don't like Trump very much anyway, and moreover, they may make their own decisions about, in fact, we think he's dangerous and problematic in all kinds of ways, and support peels off. But they're going to be reluctant, very reluctant to peel off if they think the voters are going to punish them severely at the polls under those circumstances. And so I think part of the task of trying to build support for actual removal as well as impeachment is ultimately to try to soften up that Republican voter support for Trump so that Republican senators feel like they have more flexibility to make independent decisions.
Right, and I just want to mention real quickly, you kind of have a turtles all the way down problem. Because some Republican voters clearly have expressed discomfort with the president's personal behavior, but they really don't like the opposition. So as the president cavorts about with the tweets and creates all sorts of questions about, his comportment in office, you see in focus groups and in reports that voters say, well, we kind of wish he wouldn't do that, but boy, he's doing really well with judges or
Yeah.
whatever else it is.
Right.
That's
Now-
why I think it's also hard to predict then what happens with a trial, right? Because if a long trial goes on, you bring all that stuff forward, you can imagine Republican voters starting to say, well, would a President Pence be all that bad?
Yeah.
Well, yeah, right. That was the thing that I wanted to add in, that, when you get impeachment, you don't get the opposite party's choice. What you get is the vice president. Bob, you had some interesting things to say about that, but I want to see if there's another question in the room, because if there is, I want to get to it. You have one behind you.
Just just the language of the impeachment clause when it says that they shall remove from office, is that theoretically mandatory or it's a prerogative?
So the Senate's current view is that it's automatic upon conviction. In the 19th century, they voted separately, so they would vote on whether or not to convict, and if they convicted, they then had a vote on removal, and the removal always followed upon the conviction. Yeah.
Even the beginning of proceedings, is that mandatory?
Oh, even having the trial itself? No, I think I think we're both in agreement that the Senate wouldn't have to necessarily have a trial. Yeah, that they could choose to just lay it on the table and ignore it.
Despite the word shall, your suggestion is that the word shall is mandatory language, although, of course, shall remove for high crimes and misdemeanors, and that goes to the old umpire joke of it ain't nothing till I call it. There haven't been, there aren't, one could say, high crimes and misdemeanors until the Senate has determined that there are, so welcome to the world of circular legal language. Other questions? Or other than that, we'll say, what about Mike Pence? Okay, yes, we have one.
I'm from the parliamentary system north of the border here, and we had
Welcome.
a humiliating contempt of parliament charge in 2011 that led to a no confidence vote, which was just, it wasn't even hyper-partisan, it was just to get an election, and I'm one of 4 of all 20 Canadians who actually cared about the matter. But it led me to think that, I thought one of the reasons why you guys had a temper tantrum over tea in 1776 was to avoid these sort of lack of institutional accountability and trials and juries for just these sort of reasons. So while I was horrified by what was said about proprietary norms running roughshod over constitutional rights, my real worry in your talk here was about the tension, it seemed to me, between the impeachment as a political process and as a legal process. And I was worried about due process rights for those under trial and why there aren't more entrenched norms already about what kind of process the impeached party is entitled to.
So there are some Senate expectations about what a trial would consist of. I think are somewhat consistent with our vision of what it means to have a trial. So the House doesn't have to have a trial. The House can do whatever it wants. And so it sometimes will just vote without much of an inquiry at all, let alone sort of an opportunity for the accused to actually defend themselves. Sometimes the House will, in fact, do all that. The Senate, though, historically has taken the view that the accused should be able to mount a defense, they should be able to cross-examine witnesses, they should be able to introduce evidence, they should be represented by attorneys. So there's a whole set of process of an adversarial trial process that the Senate historically has thought goes along with its constitutional obligations. If we're going to have a trial, it has to include all these. At the same time, though, they recognize that they're not exactly the same as a courtroom. So, so what the rules of evidence actually are potentially going to be different. Questions about if a senator has a conflict of interest, should they still be able to participate in the process? And the view of the Senate's been every state should be represented, and so senators shouldn't have to sit out for conflicts of interest in ways that we would find very problematic if it was a criminal process, for example. So it shares a little bit of both a political process, but also a kind of legal due process situation as well.
Okay,
And-
I'm being asked to call time, so
sorry.
I want to thank you too for fabulously worthwhile.